In this video, we're going to break down one of the most important and complex sections of the Residential Purchase Agreement, Section 14, Time Periods, Removal of Contingencies, and Cancellation Rights. This section explains 1. How contract deadlines work and must be followed. 2. When and how contingencies must be removed in writing. 3. Procedures for canceling the agreement if a party fails to perform. 4. Seller's document delivery requirements. 5. Buyer's investigation and review timelines. 6. Rules for notices to perform, NBP/NSP. 7. What happens after contingencies are removed. 8. How a demand to close escrow, DC, works. By the end of this lesson, you'll understand how to manage timeframes, avoid missed deadlines, and keep your transactions compliant by using the correct CAR forms for contingency removals, notices, and cancellations. Let's get started with Section 14, Time Periods, Removal of Contingencies, and Cancellation. Section 14A, Seller Delivery of Documents. Seller must, within the time specified in Section 3N, 1. Deliver to buyer all reports, disclosures, and information seller is responsible for under multiple sections 9B, 6, 10, 11, 13, 32, etc. This is the seller paperwork deadline. Remember, no docs equals buyer's clock often hasn't really started, and it will matter later when we talk about contingency removal. Section 14B, Buyer Review, Repair Requests, and Contingency Removal. Section 14B1, Buyer's Review Period. Within the time specified in Section 3, or as written elsewhere, buyer must 1. Complete buyer investigations. 2. Review all reports, disclosures, and information delivered by seller, including those buyer must assume per 9B 6. 3. Sign and return statutory and other disclosures that require buyer's signature in accordance with Section 11. Section 14B2, Repair/Action Requests. 1. Within that same period, buyer may submit repair requests or other action requests, CAR Form RR or RRR. 2. Seller is not obligated to agree to any repair or credit. 3. Buyer can only cancel based on contingencies actually provided in the contract. Section 14B3, Removal of Contingencies or Cancellation. By the end of the Section 3L, 3, period, or as otherwise agreed, buyer must either A. Remove the applicable contingencies in writing, or B. Cancel the agreement in writing, using CR/CC. Important details. 1. Buyer is not required to remove contingencies tied to review of documents until those documents have actually been delivered. 2. If a report is delivered after the specific contingency covering that report has already been removed or waived, that delivery does not revive the contingency, but buyer might still get cancellation rights later under the amended disclosure rules in 11G. Section 14B4, Continuation of Contingency, Buyer's last chance even if the Section 3L3 deadline has passed. Until seller actually cancels under 14C, buyer can still, in writing, either 1. Remove remaining contingencies, or 2. Cancel the agreement based on those remaining contingencies as long as buyer delivers the written removal/cancellation before seller cancels. Section 14C1, Seller Right to Cancel, Buyer Contingencies. If by the deadline buyer has not removed the relevant contingencies and not canceled, seller can 1. First deliver a notice to buyer to perform, NBP, giving buyer the contractually required time, and 2. If buyer still does nothing, seller may cancel. Cancellation authorizes the return of buyer's deposit minus seller's escrow costs already incurred. Section 14C2, Seller Right to Cancel, Buyer Contract Obligations. Seller can also cancel if buyer is not performing certain contractual duties, such as 1. Failing to deliver earnest money or increased deposit, 3D/5C. 2. Failing to provide proof of funds, loan pre-approval, or other verification. 3. Not providing required letters for VA/loan terms, assumption documents, etc. 4. Not returning signed disclosures. 5. Not cooperating with GTO reporting, 13E. 6. Not signing instructions for an increased deposit. 7. Not performing other contractual obligations listed in paragraph 32. Again, seller must 1. Deliver a notice to buyer to perform, NBP 2. If buyer still doesn't perform by the deadline, seller may cancel. Section 14C3. Seller right to cancel. Seller contingencies. Seller may cancel based on any seller contingency in Section 8 or elsewhere, as long as seller has not already removed that contingency in writing. Section 14D1. Buyer right to cancel. Seller contingencies. If seller has their own contingencies with deadlines and doesn't remove them on time, A. Buyer can issue a notice to seller to perform, NSPB. If seller still doesn't act, buyer may cancel. Section 14D2. Buyer right to cancel. Seller contract obligations. Buyer may cancel if seller has not met seller's contract duties, for example, delivering required disclosures and reports, after 1. Delivering a notice to seller to perform, NSP, and 2. The seller still fails to perform. Section 14D3. Buyer right to cancel. Buyer contingencies. Buyer may cancel under any buyer contingency in Section 8 or elsewhere, as long as that contingency has not already been removed in writing and the cancellation is done in good faith and within the allowed time. Section 14E. Notice to buyer or seller to perform. This section sets the rules for NBP/NSP. A valid notice must 1. Be in writing. 2. Be signed by the applicable party. 3. Give the other party at least 2 days after delivery to take the required action, or until the original deadline in the paragraph, whichever is later. Other key rules. 1. You cannot deliver an NBP/NSP earlier than 2 days before the scheduled performance date. 2. It doesn't apply to demand to close escrow. That's 14G with a 3-day rule. 3. If an NBP/NSP gives too little time or is otherwise incorrect, it's invalid and void, and a new notice is required. 4. If one notice lists multiple items, it's valid for any item where the timeline fits, even if invalid for others. Section 14F1. Buyer removes contingencies. Once buyer removes a contingency or cancellation right, in writing, buyer is conclusively deemed to have 1. Completed all investigations and review of related reports and disclosures. 2. Elected to proceed with the transaction. And 3. Assumed all liability and expense for A. Any missing reports/disclosures outside seller's control, and B. Any repairs or corrections related to that contingency, and C. The risk of not obtaining financing tied to that contingency. Section 14F2. Seller removes contingencies. Once seller removes a contingency, 1. Seller is deemed to have satisfied themselves about it. 2. Elected to proceed with the transaction. And 3. Given up the right to cancel based on that contingency. Section 14G. Demand to close escrow, DC. Before either party cancels, because the other side didn't close escrow, they must 1. Deliver a demand to close escrow, DCE, using the CAR form. 2. The DCE must A. Be signed by the party sending it. B. Give the other side at least 3 days after delivery to close escrow. C. Not be delivered earlier than 3 days before the scheduled COE date. If a DCE is incorrectly delivered, wrong timing, not enough days, it's invalid and a new DCE must be delivered. Section 14H. Effective cancellation on deposits. When either party properly cancels under the contract, both parties agree to sign mutual written instructions telling escrow to 1. Cancel the sale, and 2. Release the deposits to the party entitled to it, minus any fees/costs escrow has already paid. Additional points: fees may include escrow charges, vendor invoices, etc., and are paid by the party responsible under the contract. A person who refuses to sign cancellation instructions when there is no good faith dispute over who gets the money can face a civil penalty up to $1,000, Civil Code Section 1057.3. Neither agents nor escrow decide who deserves the deposit. That's between buyer and seller, and ultimately a matter for mediation, arbitration, or court if there's a dispute.